talk about this story here. A Texas school hair policy that has left a black teen suspended for months is lawful, according to a judge. So, once again, I'm Tyrone Bowman. This is Tyrone Bowman Tonight. According to NBC News, a judge on Thursday ruled that a Texas high school was not violating the state's Crown Act by punishing a black teen over the length of his dreadlocks. Darrell George, 18 years of age, has been disciplined for much of the school year after refusing to cut his hair to comply with the school dress code. So this is the young man in question right here. I'm leaving it up for a prolonged period of time for a purpose. All right, now let's unpack this story. State District Judge Chap Kane III said the Barbers Hill Independent School District dress code and grooming policies do not violate the Crown Act, which prohibits race-based hair discrimination at work, school, and in housing facilities in the state. The decision was met with sighs and gasps by many of those gathered in the courthouse, which included student Darrell George's supporters and natural hair advocates. Kane said the district's policy does not prohibit nor does it discriminate against male students who wear beards, locks, or twists. Candace Matthews, the family spokesperson, told reporters after the trial that George left with tears in his eyes and lamented the decision. All because of my hair, he said, according to Matthews. I can't get my education because of my hair. I can't be around my peers and enjoy my junior year because of my hair. Matthews said the family has vowed not to lay down. They will continue to fight. The decision is the latest development in a months-long battle between George's family and the Barbers Hill Independent School District. We appreciate clarification from the court because it's an important question. Sarah Leon, a representative for the district, said of the ruling, we're glad to understand what the law means. Just because it's a law doesn't make it just. George, a junior at the high school in Bellevue, outside of Houston, has been in school suspension or at an off-site disciplinary program since August, when school officials said George's hair violated the dress code regulating the length of a boy's hair. George and his family have refused to cut his hair, in which they should not have to, which he wears neatly braided on top of his head, away from his face and neck. They argued that George's punishment violates the state's newly implemented, it's a new law. I see. I wonder who conceived this law. The district disputed the claim, holding that the law doesn't address hair length. So let me show you this young man again, Darrell George. I know what the law represents. It's code. It's a dog whistle. Listen to me. It is a code. It is a dog whistle. It's sending an indiscriminate message. And some people think we're going back to the time of the 40s and the 50s and the 60s. Well, guess what? We're woke and we're staying woke, whether you all like it or not. According to the student handbook, male students' hair cannot exceed past the eyebrows or earlobes. The district filed a lawsuit in September, requesting that a judge clarify whether that's the case. Last month, Kane ordered the case to go to trial. The case boiled down to whether the district's length regulations were in violation of the Crown Act. Kane ruled on Thursday that they were not. The Crown Act does not render unlawful those proportions of Barber Hill's dress code, he said. Leon, the district representative, said during the trial that the district's policy is consistent with the Crown Act and prevents the school from discriminating against George based on wearing dreadlocks, but he can't wear them at a length that exceeds the dress code. She reiterated the district's claim that hair length is not covered by the law, and arguments that include length amount to additional protections beyond the prohibited. Listen to this statement. She reiterated the district claims that hair length is not covered by the law and arguments that include length amount to additional protections beyond the prohibition of discrimination, protections that would suspend other race-neutral school policy. What the hell does that mean? Seriously, what difference does it make? If this was another ethnic group, because of religious reasons, that wore their hair in a particular style, none of this would be happening or going on. Ali Booker, the George's family attorney, disagreed. She said that protective styles often require length achieved by adding synthetic or human hair to a person's hair. Under Barbara Hill's policy, it would be impossible for students to wear protective styles, Booker said. There is no Crown Act, not at BHISD, she said, referring to the school. She added later in her closing argument, their grooming code attacks the style. During the trial, Booker called to the stand State Representative Ron Reynolds, who helped write Texas's Crown Act. He said that length is included in the law. Length was referred with the very nature of the style. Reynolds told the court, anyone familiar knows it requires a certain amount of length, blah, 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 blah. Now listen to this in closing. This is not the first time the district has been at the center of a dispute over its hair policies. In 2020, 2 students filed lawsuits after they were suspended over the length of their dreadlocks. Both students withdrew from the school. And that's exactly what Darryl George's parents need to do. Stop begging these people to let your son come to school and wear his hair the way he wants to wear it. Just take him out and sue the school district. Both students withdrew from the school, and the lawsuits are pending. One of them eventually returned after a judge granted a temporary injunction for him to return to campus. Stand your ground. I'm Tyrone Bowman. Never surrender. Never quit.